thank you very much also for your kind introduction. I'm not sure how much time we're gonna have for our joint presentation, but I want to try to be as briefly as possible so as to leave also room for discussion. But the core question the organizer of this workshop or roundtable put to us, whether soft law can be considered the ultimate solution for better regulation of private law in the European Union, is a question that triggers numerous issues and not only of general aspects of EU law and regulatory aspects of the European Union, but also obviously of private law. And this is also why Anna and I decided to join forces on this particular topic, because it's quite a challenging one, I think, both from a public law and a private law perspective. Unfortunately, we do not have yet a draft paper, so we will still be presenting some elementary thoughts, I may say, on the topic, so we also welcome any comments and suggestions you may have. So what we are going to talk about, what I'm going to talk about in the first part of the presentation is on how the use of soft law is part of the mixed instrumental toolbox of the European Union and how that fits in with better regulation and the smart regulation strategy the EU has developed, in particular the Commission. That will only be a very brief introduction. What I want to focus on mainly is also the question about what kind of regulatory problems soft law can potentially fix, because if we talk in terms of is this the best solution, we must also talk about, well, what are the relevant regulatory problems soft law could actually remedy. And Anna will pick up on this in the second part of the presentation and see also how this applies to the context of European private law. So, talking about a better regulation strategy, the Union's mixed toolbox and soft law kind of in conjunction, very basically one can say, well, the better regulation strategy as it has developed from the beginning of the, you could say, of the turn of the century in particular, the focus has been on producing less regulation, better regulation, and more diversified regulation, and the use of other types of instruments. And obviously, this is where the use of soft law instruments comes in. And this can be actually also traced back, at least the development of the better regulation strategy, to the introduction of the subsidiarity and proportionality principles already at the beginning of the 1990s, and the use of soft law was actually propagated already in the Edinburgh Council conclusions of 1992 as a tool that could be give substance, in fact, to the application of these principles. So when we talk about soft law, what are we actually talking about? And here I rely on a definition I've developed in earlier research. I defined soft law as rules of conduct that are laid down in instruments which have not been attributed legally binding force as such, but which nevertheless may gain certain indirect legal effects and that are aimed at and may produce practical effects. As such, we can say this phenomenon of soft law and producing this kind of rules has always been present in the European Union, also before the development of the better regulation strategy. So as such, we would say, are we talking about new instruments? No, we are not talking about new instruments, and they were advocated even before and very much used before the launch of this strategy. But what I think is important also from the perspective of our topic here and the discussion later on when it comes to private law in particular, well, we must recognize that soft law is a very heterogeneous phenomenon, and it means we need to kind of distinguish between different types and functions of soft law. And first of all, we need to make a distinction between soft law instruments that are located on the public law level, and later on we'll see also instruments that are located on the private level or on the public-private level in between. So on the EU public law level, within the specific context of the EU, we can distinguish, first of all, what I've labeled as preparatory and informative instruments, the instruments that you could say that serve some kind of pre-law function, the green papers, white papers, all different kinds of communications that are in fact not soft law in themselves because they do not establish rules of conduct themselves, but they are geared towards developing such rules of conduct in the future in whatever form, be it in hard legislation or possibly in other forms. So they lead up to such rules of conduct. Well, the second type we can distinguish are the instruments we can label as post-legislative guidance instruments, or we could label them as administrative soft law, and they actually resemble also the type of policy guidelines you may encounter in national legal systems. And you will find them under the label of interpretive communications, etc., in the Commission's practice. And importantly, you could say these instruments serve a kind of post-law function because they are related to already existing EU law, and they seek to give more guidance on how to interpret existing primary and secondary EU law and to guide the application and implementation of primary and secondary EU law in the member states. So they're always linked to existing EU law. And the third type, you could say, have a more self-standing function. I labeled them as steering instruments. You may have formal steering instruments that are actually recognized in EU law, such as the instrument of the recommendation, but you also have a lot of non-formal steering instruments that are not recognized as an EU instrument, but they are being used in practice, such as codes of conduct, resolutions, etc. And here you could say many of these instruments fulfill some kind of parallel function. They are used instead of legislation. You could say they establish independent rules of conduct that are not as such linked to already or linked to existing EU law, but they seek to coordinate national laws and policies in a non-binding way. On the public-private level, then we can say we find two different types. First of all, co-regulation. It's the mixed public-private instrument. And here it takes many different forms in EU law. Voluntary agreements, for instance, within the framework of the European social dialogue you could think of. Also technical standard setting through organizations like Senden and Senelec. And I think what is important in the EU law context, at least how the Commission and the other institutions operationalize co-regulation in the interinstitutional agreement on better lawmaking. It's a very top-down process. It's very much conditioned by the EU institutions, and in that sense you could say it also serves some kind of post-law function. It's kind of you have some kind of regulatory or legislative framework set at an EU level, and the further substantiation is left to other types of organizations, and sometimes these are private organizations. But you could also say in other cases, well, they fulfill a parallel function and they are actually establishing more self-standing rules, not as such connected to primary or secondary EU law. And then finally, the last type is self-regulation, pure self-regulation, you could say, where it's really left to private organizations to establish codes of conduct or codes of practice as instead of the EU moving towards the establishment of legislation. So my first I think observation and also a reason why I give this overview is to kind of emphasize that soft law is not to be considered the ultimate solution. It's clearly part of a broader regulatory landscape. And you could say, well, soft law fits within a system of instrumental complementarity in a way. It complements hard law instruments, and it's not necessarily functioning as an alternative to such hard legislation, but it's part of a system where hard law instruments and soft law instruments find its place, and where this can be of a public and a private nature. Secondly, my second point, then what kind of regulatory problems can soft law fix or mitigate? What are really, you could say, important reasons that can make regulators and also legislators kind of move towards the use of soft law instruments? Well, very generally, one can say, well, it's to avoid over-regulation, in the sense, in the relationship EU member state, and there you could say it's clearly within the framework of the use of, or putting the subsidiarity principle to practice. The EU should not be regulating more than is really necessary, also from a national perspective, but also more generally, one can say, well, in applying the proportionality principle, you should be regulating on the appropriate level, and you do not need to regulate everything in a hard law. Well, the second type of instruments I've mentioned, you could say they really also seek to remedy legislative deficits. By using interpretive communications, you can say, well, you can kind of undercut vagueness that is in the legislation, or you could say, well, here, obviously, the national legislator will need more guidance as to what is the specific meaning of the legislation. And you could also say, well, they are being used to enhance legal certainty and equal treatment. It's also an important reason why this administrative type of soft law is being used. But then more interesting, I think, also from the perspective of private law is, well, that the steering instruments and the self- and co-regulatory devices are used for a number of other reasons. They are being resorted to in the EU context when there is no legislative competence, for instance. That may be an important rationale. Political deadlock may be another reason. So you may resort to the use of soft law because there is no consensus on hard legislative approaches, and in that sense, actually, the use of soft law may also prepare the ground for future hard legislation. Thirdly, I think it can fill important regulatory gaps where the current legislation is still falling short, and you may still have some necessity for some further coordination. And finally, I think especially also the use of co-regulation and self-regulation may remedy certain deficits in terms of democratic and stakeholder support. So it's also a means to kind of enhance this level of support, which in the end may actually also mean that there may be more support for other regulatory approaches. So my second finding or point to emphasize would be, well, by using these different forms of soft law, we can say actually there is a certain desire underlying this use of soft law to enhance the coherence, at least in a substantive way, of laws and policies that are being developed, you could say on the EU level, but also that need to find some ground in the national legal system. So is an important device, actually, I think, to build substantive alignment between EU policies and national policies. And actually, I think it connects very much to the point that was raised by Jan this morning on the different rationalities underlying EU law and national law. The question is, to what extent are these indeed different rationalities? And actually, I think soft law plays a role in kind of perhaps reconciling these different rationalities, in kind of identifying, at least in a very initial way, some common ground between national and EU approaches and interests. But this is something we could discuss further. And this will be my last point, because I know I'm talking too long. But my last point would be about how does soft law fit within the smart regulation strategy the Commission has initiated 2 years ago, because I think new steps have been made in the development of the better regulation strategy, and the question is, well, what would that mean for the use of soft law? And actually, I think there are interesting links one could make between the smart regulation strategy and the use of soft law, because the smart regulation strategy, what makes better regulation, smart regulation, as I understand the Commission's approach, there are 3 elements important. It's ensuring the quality of regulation throughout the whole policy cycle. Secondly, the emphasis on better regulation being a shared responsibility and a collective effort for the EU and the Member States in all policy areas. And thirdly, strengthening the voice of citizens and stakeholders. In itself, this is nothing new. It is part already of the better regulation strategy, but I think it has gained particular emphasis with this smart regulation strategy. And you could say, well, the use of soft law, as I just kind of identified the different manifestations, fits very well with the different, these different elements of the smart regulation strategy. And this brings me to my final point. I think what the Commission kind of is proposing in this smart regulation strategy, or at least is aiming at, is in developing an integrated and kind of circular process of regulation and enforcement in Europe. And I think soft law could play an important role, in fact, in kind of developing this, this system further in this way, and kind of connecting the 2 layers of regulation and enforcement. That's what I had to say. And again, I took too much time, but I hope not too much time of honor. So